All right, part two of our video lecture this week is going to focus on the 14th Amendment, specifically the Equal Protection Clause that is inherent in the 14th Amendment. So we'll just jump right into it here. The 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. Another way to explain what this is stating: state actors cannot discriminate against people based on specific classifications. Basically, the Equal Protection Clause within the 14th Amendment is triggered anytime a group of people or individuals are treated differently based on a particular classification. We'll talk about the different types of classifications that are inherent in the 14th Amendment, but know that the classifications that receive the most scrutiny or restraint generally involve what we call immutable characteristics. So things people are born with, like race, ethnicity, etc. So all in all, what we're talking about here with the 14th Amendment is this concept of discrimination, and that it is illegal for state actors to discriminate under the 14th Amendment. So a little bit of background here on the 14th Amendment. Keep in mind that we've got two things happening here, two clauses existing within the 14th Amendment. We have that due process clause that we talked about last week, and we have this equal protection clause dealing with discrimination. So in terms of context here, you'll see that the 14th Amendment was adopted not long after the Civil War, so in 1868. And you can see that the amendment that came previously to the 14th Amendment was the 13th Amendment, which of course we know is the amendment that abolished slavery. So it made slavery illegal in this country. But unfortunately, the 13th Amendment did not quite do enough, because you still had states in the South that were creating their own policies and laws, basically known as black codes, which basically made it impossible for those recently freed slaves to pursue any kind of normal life where they were provided basic protections under the laws. So federal government noticed, hey, the 13th Amendment didn't go quite far enough, so we need another amendment that's not only going to abolish slavery, but take it a step further, right? Actually grant citizenship to these recently freed slaves and provide the same basic liberties and freedoms that our other citizens are provided. So that's really what the purpose of the 14th Amendment was at the time. You'll see that we've got some expanded coverage over time. So the Equal Protection Clause doesn't just deal with issues of racial discrimination anymore. It includes a number of other classifications. So as we note through a lot of the concepts we're looking at, while the Constitution is written hundreds of years ago now, it still evolves and changes over time based on court precedent. Okay, so real quick before we look at the levels of scrutiny under the 14th Amendment, it's important to note that we've basically got these two types of discrimination that can occur. So we've got de jure discrimination, which, as you can see here, is essentially discrimination that's actually included as part of a law or policy. And that law or policy has a clearly defined discriminatory purpose. So this is pretty purposeful and obvious discrimination, and under the 14th Amendment, de jure discrimination is not acceptable. An example of this would be, prior to Title IX passing in the 70s, it was pretty common for universities and major universities to have policies against accepting women or admitting women to their universities. These policies were obviously clearly discriminatory, right? They were saying we won't accept women because of their gender. So that was an example of de jure discrimination, very purposeful, very obvious discrimination. But we also have discrimination that maybe isn't as clear in terms of its definition or purpose, but has a discriminatory effect. That is de facto discrimination. So these are less obvious examples of discrimination, but ones that have a discriminatory effect on the people that they impact. So an example of this would be, let's say that a public recs department has a position they're hiring for, facility manager, and within their job requirements, they decide they want to make it a requirement that the person who gets that job has to be able to lift 200 pounds. on its surface, it doesn't seem like a discriminatory policy, right? But it certainly has potentially a discriminatory effect, right? So that people, probably particularly women, aren't going to be able to meet that requirement, which is pretty unrealistic, right? To be able to lift 200 pounds. So while the policy itself might not be discriminatory, it has a discriminatory effect. Your textbook talks about the firefighter example of how they had to adjust some of their requirements over time in order to avoid having de facto discrimination or discriminatory policies in place. So just important to keep in mind the difference between de jure and de facto discrimination. It's much more difficult to defend de jure discrimination in court because of its clearly defined discriminatory purpose. Okay, so equal protection cases are a bit unique in that they require a court to first determine a level of scrutiny that they are going to apply before even reviewing the case. So basically, the court has to determine what type of discrimination is occurring here. Basically, what's the classification of discrimination? And then based on that type of discrimination, they select a level of scrutiny which to review the case. So when we refer to scrutiny in this context, we're referring to the way in which the court analyzes whether state action should be condoned or rejected. So the degree to which someone or the court analyzes the issue is what we're referring to when we say scrutiny. Higher levels of scrutiny are going to make it more difficult for a defendant to defend themselves, where lower levels of scrutiny make it easier. So basically the questions the court is going to ask in any equal protection case is, what was the discrimination based on? What was the purpose behind this particular policy or decision? And does the policy actually accomplish its purpose without being discriminatory? If the answer is yes, then the state actor is likely safe. If it's no, the plaintiff probably has a pretty good case. So you can see here we have 3 established levels of scrutiny that a court can apply in an equal protection case. And these levels have been established over time through several court cases, and they are pretty widely or broadly applied across both state and federal court systems. So you can see our highest level of scrutiny that a court can apply is strict scrutiny. And we're going to talk in detail over the course of the next few slides about each of these levels and what they entail. But you can see here, based on our chart, we have strict scrutiny in cases where the plaintiff almost always wins, so the court favors the plaintiff. We have intermediate scrutiny, where the courts typically favor the plaintiff, but that's not always the case. And then we have rational basis, which is our lowest level of scrutiny here. In those cases, the courts generally favor the defendant. So over the course of the next few slides, I'm going to highlight these different levels of scrutiny and also try to provide some example cases so that you get the idea of why the courts might favor a particular party in these cases and what that looks like for the state actors involved. Okay, let's start with strict scrutiny. So essentially we said strict scrutiny is the highest level of scrutiny that a court can apply or view a case through. Basically, cases involving strict scrutiny involve what we call suspect classification or a classification linked to a fundamental right. What that means is the cases involving strict scrutiny are generally discrimination based on some of those immutable characteristics, so things like race, ethnicity, national origin. Basically, the courts have determined that this type of discrimination is unjustifiable, right? Essentially, there's rarely ever a situation where a state actor can defend discrimination based on race, national origin, or ethnicity. So it's very difficult for a defendant to defend themselves in a strict scrutiny case. Keep in mind, they can still try to show they had some kind of compelling interest or reason for having the policy in place, but very rarely are they going to be able to do that, right? So as long as the plaintiff can actually prove evidence of discrimination, so the example I use is someone claims they didn't get a job because of their race, then they would be able to likely win in court. So very difficult for a defendant to defend themselves in a strict scrutiny case. This is the highest level in terms of those 3 levels that we looked at on the other slide. I'll give you an example case here, and your textbook talks about this case as well. The Louisiana High School Athletic Association case. This one goes back quite a few years, but is still relevant today. Basically, you had St. Augustine High School, which was an all-black school. They wanted to join the Louisiana High School Athletic Association, so become competing members so they could compete in championship events. The High School Athletic Association required a 2/3 vote from its member schools, so the schools that were already members of the association. Keep in mind that predominantly the existing members of the association were white schools. This is in the late 60s when integration is still happening across the country. And based on the vote to allow St. Augustine in, they denied membership. So basically the members voted against allowing St. Augustine to join the athletic association. St. Augustine files a lawsuit under the Equal Protection Clause. The court says this is very clearly strict scrutiny lens that needs to be applied because we're dealing with discrimination based on race. So basically, they were denied access to this high school athletic association for no other reason other than they were made of predominantly black students, and the existing association wanted to keep them out. So as you can imagine, the court did side with St. Augustine in this case. They said there's no compelling reason for the athletic association to deny them entry, and therefore they had to allow entry after that point. So again, just an example of how very, very rarely is it going to be possible for a defendant state actor to defend any kind of discrimination based on these immutable characteristics like race. Okay, so our next level of scrutiny under the Equal Protection Clause is what we know as intermediate scrutiny. So if we're ranking the 3 levels, this is going to fall in the middle in terms of second highest level. And in general, the cases involving intermediate scrutiny have been based on gender. So historically, any discrimination case based on gender that's filed under the 14th Amendment is going to be viewed as an intermediate scrutiny case. Now keep in mind that in recent years, this particular level of scrutiny has also included cases of sexual orientation and gender identification. So like I've mentioned before, even though this law is put in place, the constitutional law amendment has been put in place years ago, decades ago, it's still evolving and changing in terms of how the court applies it. So these recent cases are adding groups of people to be considered under intermediate scrutiny. So now it's not just discrimination based on gender, but cases involving discrimination based on sexual orientation or gender identification could also be viewed at this level based on those prior cases. So again, in cases of discrimination based on gender, it's somewhat difficult for a defendant to defend themselves, right, based on this discrimination. But if they can show that they had an important governmental reason for having a policy in place, they may be able to do so. It's still difficult to show a valid reason for discrimination based on gender, but if they can show they have an important reason for having such policy in place, they might be able to win the case. In the prior scrutiny level of strict scrutiny, we said that they had to be able to show a compelling government reason in order to defend themselves. So the difference between these words, you might think, what's the difference between compelling and important? But the difference can be described as compelling interest means they must show, important reason means they should show. So just give you an idea there in terms of the difference. So how does the intermediate scrutiny level apply in our field? As you can imagine, we have a long history of court cases that deal with gender discrimination in sport and recreation. And so I just wanted to highlight a few, I think, precedent-setting cases that impact us now. The first of which is this Hoover versus Michael John case from 1977. You had Hoover, who was a young high school female athlete. She wanted to play soccer for her Colorado high school, but the state high school athletic association had a rule against girls playing soccer, and the school did not have a girls team, so they didn't even offer an opportunity. So she went out and tried to compete with the boys team. The school denied her the ability to do so. They said this was an issue of safety, right? So their important governmental reason for having the policy in place is that they're worried about her safety as an individual and as a female. She claimed this is a violation of her equal protection rights. So again, the court viewed her case under the intermediate scrutiny lens because this was dealing with discrimination based on gender. And ultimately, the judge ruled in her favor. He said that the school district did not have a rule about minimum size requirements for the boys who were participating in soccer, and therefore it didn't make sense that they would argue that all girls would be too small or too frail to play the same game. So as you can imagine, this is a pretty big landmark case. And since then, we've seen other cases where girls have won access to participate in co-educational sporting events. Keep in mind there are still issues where the sexes are kept separate, and we'll talk a little bit more about that when we get to our unit on Title IX. But just know that in recent years there has been more access provided to those girls when there is not an opportunity for them to participate in a female team. Another example case here where intermediate scrutiny was applied is this Ludke versus Kuhn case from 1978. This was a case where a news reporter, Ludke, basically reported on the New York Yankees, but she was not allowed access to the team locker room because she was female. And you might be thinking, how can this case be a constitutional law case because the Yankees are a private organization? Well, because the Yankees stadium at the time had been funded primarily through public dollars. If you remember back to our lesson last week where we talked about that entanglement theory, because they were so entangled with the city, who was considered a state actor, the court did allow this case to be reviewed under constitutional law. So that was a little sidebar, but in this case, she was arguing that she was being denied access to the locker room, unlike her male counterparts who were provided access to the players after the game. Obviously, this limits her ability to do her job, right, if she's not provided the same level of access. So she sued Major League Baseball and the Yankees under the Equal Protection Clause, and as you can imagine, they decided we're going to review this under intermediate scrutiny because it's dealing with gender discrimination. And for its case, the Yankees and Major League Baseball argued that, the state had an important governmental interest in protecting the privacy of the players, right, and promoting what they called a family atmosphere in the sport. So by allowing a woman in the locker room, then we couldn't keep up these traditional standards of family values or decency because, players after the game are standing around in towels, right? They're taking showers. So that's what their argument was, right? Their important governmental reason for having this policy in place was that doing so or allowing her access would take away that standard they created to have this family atmosphere and provide some privacy to the players. Well, the court agreed that the players did have a right to privacy, but they did not think that barring women from the locker room was substantially related to that interest, right? If you're allowing other reporters who are male access, then you're not giving them a level of privacy anyway, right? So basically, they agreed that there were less restrictive ways for them to manage the situation, like maybe separate the reporters by a door so they could have some privacy while they're changing, or give them towels to cover up, right? There are other ways of dealing with this situation than banning a particular gender from accessing the locker room. So she was successful in her case, and as you can imagine, again, that's a pretty landmark case in terms of precedent, right? Because now we know that female sports reporters have the same access as their male counterparts when reporting on games. Okay, one last level of scrutiny here that I want to discuss, and that's our lowest level of scrutiny, which is what we know as rational basis. So basically anything that wasn't covered by our other two levels of scrutiny is going to fall under our category of rational basis. So anything that didn't meet the requirement of strict or intermediate scrutiny is going to fall under rational basis. So you can see I've given you a couple of examples here of things that commonly come up under rational basis. So discrimination based on age, discrimination based on economic or social background. We've seen some cases involving athletic participation as a category or classification for discrimination under rational basis. As you can see from our chart here, cases that meet the requirement of rational basis tend to favor the defendant, okay? Meaning that of our three levels here, it is easiest for a defendant state actor to defend themselves in a rational basis case. Basically, all they have to do is provide a sound reasoning for having a policy in place. If they do that, generally they're going to win the case. So it's much easier for defendant state actors to defend themselves in a rational basis case than it was those two other levels. So an example case from your book is this Blue versus University Interscholastic League. This was the case where the court held that high school age rule that prohibited students over the age of 19 from participating in athletic programs could be instituted and was fair because they agreed that this was an issue of fair competition, right? Having student athletes that are over the age of 19 participating at the high school level was not going to provide a fair playing field for the other teams and athletes playing the school. And it was also an issue of physical maturity, right? So having this policy in place was there to keep the other players safe, right? Because in theory, someone who's 19 or older is probably more physically developed than, say, a 15 or 16-year-old playing on those other teams. So because they were able to provide this sound reasoning in court, the judge then agreed with the university scholastic league in this case and said it is okay to create this rule that limits student athletes from participating who are over a certain age. So again, that's an example of a case that is viewed through the rational basis lens. Again, I think if you're having trouble with understanding these three levels of scrutiny, I hope this table or this visual representation can help make sense of it. Again, the idea here is that if an equal protection case comes to the court is going to look at the three levels and determine which level is appropriate based on the type of discrimination they see happening or being accused in the case. From there, they will look at the facts of the case and determine whether or not the plaintiff or defendant reasoning or rationale is favored. And again, in terms of who the court favors, it's much more difficult for a defendant state actor to defend discrimination based on those immutable characters found in strict scrutiny. It's also difficult for them to defend at the intermediate scrutiny level, although there are cases where they can, if they can come up with an important governmental reason. And then finally, that rational basis category tends to favor the defendant, right? All they have to do is show sound reasoning for having a policy in place, and if they can do so, they're likely to win.